living trust. So we're going to talk about what that means and its many benefits. So a living trust, you can revoke it or modify it at any point during your life. So if you change your beneficiaries, you change your trustees, if you have a change in your finances, you want to make sure that your living trust is updated. So you can modify it, you can make amendments to it. If you need major changes, you can do a full restatement. So this document, your estate plan, your living trust, is flexible and is designed to meet the needs of your family. So it should be updated as your family is updated, or as there are changes in your family. Management of assets during incapacity. This is a huge benefit, honestly. People focus on the benefits of staying out of probate and the after death benefits of a trust, but the benefits during your lifetime are just as powerful. If you have a family member who has a long incapacity and illness, or with elderly parents when they go through mental decline, Alzheimer's, dementia, things like that, if you don't have this plan in place, you're going through the conservatorship process, which is basically like a living probate. And it is just a giant mess. I have a client, I'm doing a trust for her now. She came to me after her father died, and he did not have any of the stuff set up during his lifetime. So she had a conservatorship for him, and it was a train wreck. It took just a crazy amount of time and money and hassle, and it's just not necessary. So a living trust is going to take you away from the court system, both after you die and also while you're alive and incapacitated.
John Eric?
Yes.
I do have two questions that have come in through the chat.
Awesome.
And the first one is, what and who are the trustors and the trustees?
Excellent question. A trustor is the person who creates it. For a married couple, it's husband and wife. For an individual, they are the ones who create it. The trustee is somebody who manages the assets of the trust for the benefit of the beneficiaries. So they are what we call in our industry a fiduciary. And what that means is that they have a legal obligation to manage the trust property for the sole benefit of the beneficiaries and not themselves. So they can't take personal benefit in any way, shape, or form from managing the trust for somebody else. So while you're alive and in good health, you, the creator of the trust, are also the trustee. There's no third party involved until you are no longer able to do the job. And that's a huge benefit because it's there if you need it, not if you don't. So it's not going to interfere in your life at all by having a trust and putting your assets into trust.
And I know that you'll probably get to this in a little bit, so I might table this question, but
okay.
I had a question that came in regarding divorce and remarriage and things like that when it comes to will and testament. Do you want to address that in a little bit and I can circle back to you, or do you want to answer that question now?
I mean, we'll get to that in just a little bit. That is, okay. But that is, to be honest with you, one of the most amazing benefits of the trust and doing an estate plan is the ability to customize your estate plan for your family and your particular situation. When we go back to the default system of California, that a big chunk of that is stuck back in the 1950s. Honestly, it is not adapted to the way Californians live today. It's more Aussie and Harriet and less modern family. So for blended families, having a living trust is like that much more essential because it has to reflect what's important to you and not some basically Stone Age view of how people live, right? So the probate code does evolve in certain areas, but a lot of the fundamental assumptions are really stuck back in a completely different era. So, the default estate plan that California gives everybody is a train wreck for anybody, but for a blended family, for a mixed family, it's really, really bad.
Okay. And then another question that came in that's regarding the trustee trustor thing. Can a trustee be a trustor, or are they two completely separate functions?
It's two different roles. A trustor is the person who creates the document. The trustee is the person who manages it. So while you're alive, you're wearing both hats, so to speak. You're the one who created it, and you're the one who manages it.
Okay.
The trustor role never changes ever because the people who sign the trust are always the person who created it. It's the trustee role that changes.
Okay. And then last question on that same note, and then I'll give you back the mic. If someone does not want to utilize a family member or a friend to be a trustee, can they utilize another person? Is there another person that they can utilize?
Yes, absolutely. So yeah, in California, this is one of the few areas where California is way ahead of everybody else, the other states. So you can hire a professional trustee to manage the money. So, most banks have a trust company attached to it. And that's an excellent source of trusteeship. I actually began my career as a trust officer at Bank of the West. My business partner began his career as a trust officer at Comerica. This is way back in the 1990s. And so, but in addition to that, there are what we call professional fiduciaries. And there's an organization called the Professional Fiduciary Association of California. And those are the licensed, insured, bonded individuals who are professional. They're governed by the probate code, and they assist families kind of on an hourly basis. So depending on the needs of the family, it can either be like a financial trustee or it can be a professional fiduciary. And so, in other states, they don't have that. And it's honestly the Wild West in a whole bunch of other states for who's allowed to be a trustee for another person. And it's kind of it's real bad.
Okay, perfect. Thank you so much. And it looks like, I'm getting a lot of questions in here. Some of them I know you're going to be answering. The average cost of the living trust. I know that's going to be answered soon. And also who's in charge of distribution of estate when that time comes. I know that you're going to be getting into that. So I will table those questions just for a couple of moments while I let you get to it.
Excellent. So wrapping up some of the benefits of a trust. Item 4, complete control over distributions. That's what somebody was asking. The trustee is the person in charge of distributions, but you, the person who creates the trust, are in charge of how and when and under what terms that money and those assets are distributed. So you can get really creative and customize it individually for each family and each family member and each child or other beneficiary. You can customize it. That's we'll talk about that in a second. That's a really powerful feature, is the ability to customize distributions. And then again, the asset protection feature for your kids, when they inherit the money, how to protect them from people who would separate them from their money, their inheritance. We're going to talk a lot about that in a second. Again, California has a default for every part of your estate plan, right? So you have a default estate plan. The default age of inheritance, and this is true in all states, is age 18. Right? Until somebody hits 18, a child cannot inherit assets via an inheritance without some kind of court involvement. Once they're 18, if there's no other age specified or no other documents in place, a child's going to get everything at age 18, free and clear. They can lose it, they can spend it, and can do whatever they want. And as parents, we like to think there's a tough decision to be made here between, paying for college out of their inheritance and buying a fancy car and buying some friends. I can tell you, it's not at all a difficult decision for a kid. They go for the right every time. They go for the car. There are national statistics about, because age 18 is the universal age, the most dominant age of inheritance nationally, whole financial planning companies have analyzed how long it takes for a kid to blow through their money at age 18. And most of the vast consensus is the money's gone by 21 or 22. Don't go to college, take the money, don't really pay attention to it, didn't earn it, have no connection to how hard it was to earn that money. It's monopoly money. I inherited it. I'm 18. I'm having fun. Why go to college and stress myself out? I can just, do all my other things that I want to do with money and not have to sacrifice at all. And so by the time they're 21, 22, they've blown through the inheritance entirely and back to square one, going back to college in their mid 20s after blowing through what you left them in your estate plan. So a living trust gives you control over distribution to your kids. So the trustee, after you've died, the trustee is the person who is enforcing the decisions on when your children receive it. But you, when you create your living trust, you are the person who sets the terms for how and when and under what terms they will inherit their property. And that's honestly, this is some of the most powerful stuff that a living trust gives you. You can either give it to them all at once or distribute it to them in stages. Kind of the generic language would say that the income from the trust, the income it's producing, begins at age 18 and is paid out to them monthly, semi-annually, quarterly, whatever. and then they're allowed to access the principal of their trust for just, the discretionary principal distributions. We call health, anything healthcare related, anything education related. That's defined broadly, not just universities. It's defined very broadly. All educational expenses, room, tuition, books, board, all the stuff a child needs to get that education. Maintenance and support, those are legal terms that mean necessities of life. So for everything a child needs money for, their trust, even if it remains in trust, their money is available to them for what they need. What it's not available for is luxuries, therapeutic shopping sprees, trips around the world, party money. That's not available from the trust. So then distributing to them in stages when they're older has the benefit of obviously putting the majority of the money in their hands when they're older, more mature, have worked, have graduated, have built a family, have other obligations, right? Going back to the last slide, an 18-year-old who receives a big inheritance doesn't have a lot of claim on that money, right? They don't have as many financial obligations as a 35-year-old, right? Somebody who has their own family, their own kids, bills, mortgages, taxes, other expenses and obligations. So somebody receiving a whole pile of money at 18 says, great, I can do this whatever I want. Somebody who has those other obligations and expenses in their life say, great, now's the time to pay for my own kids' college and front that money so I don't have to stress about that. Now I can take this money and get current on other bills and things like that and have some left over. But that's the primary difference and the benefit of a trust is it allows you to customize distributions according to the needs of your children. And so when people ask us, how often do I update my living trust once I create it? This is an excellent area that can and should be revised as your kids get older, right? Only you guys know your kids and their maturity and their ability to handle money. And when a child's small, honestly, you're just guessing. But as a child gets into their teen years, you're going to get a much better handle on that. And even when your kids are adults, you're going to say, well, this child needs extra help and this child doesn't, right? This, when we talk about asset protection to protect them from people who would separate them from their money, maybe you have a child who's in a high risk occupation where they could be sued. Or maybe your child works for the government or an institution that covers their liability and they're not liable. So there's a child that doesn't need as much protection. So all these things are wonderful customizations that you can build into your estate plan, but it's also why you should update your estate plan as your family changes. So the way at a high level, the way I describe a living trust to my clients, it is a container for your assets. So step one, work with a law firm to create your container according to the terms that are important to you. Step two, funding your living trust is putting stuff into the container. So often people come to me being named as the trustee for their parents and they say, well, my mom now has dementia and she's asked me to, I now need to administer her trust. They say, is this old trust any good? And the answer is, that's only part of the equation. Is the container good or bad container? The other question is it full or empty or partially full, right? And doing this for 20 years, when clients come to us in those shoes, almost never is something fully funded. Almost never have I seen somebody come to my office managing their parents' money and 100% is in their trust. And we'll talk about examples of how that can really cost a family money later on. So this is why we emphasize funding, because obviously the appropriate beneficiaries of your trust are your kids and your other, whether they be charities, other beneficiaries of your assets. You don't want it to go to your future ex-son-in-law, this poor guy, or these other people who are trying to separate your kids from their inheritance, right? Taxes, credit cards, asset protection or trial lawyers and other people. So you want to make sure that your money is left to your children in a protected manner. So when families ask us about asset protection, for an 18-year-old, you're protecting that child from themselves and their own poor decisions. When your child is in their 20s and 30s and 40s, you're protecting them from other people. Number one thing people ask me, how do I make sure I leave my money to my kid doesn't wind up if they go through a divorce? How do I make sure that my child's inheritance doesn't wind up getting commingled in a divorce settlement? Well, the answer is if they're not going to do a prenup, then they're going to need to have a trust, leave the money in trust, and then make sure that that money does not distribute out for any other purpose other than your child. So we've already talked about this kind of at a high level. Spendthrift trust provisions is the way that your living trust money is left to your child in an asset protected manner. While the money remains in trust until it's in their own individual wallet, their inheritance is protected. Creditors cannot get at the assets. They can't force distributions. They do not, your kids don't own or control the trust. The trustee manages it for their benefit. They have a right to the money, but it is not theirs to own. And under the law for both taxes and for lawsuits and asset protection, that distinction is critical. The difference between owning something and having the use or control of it are night and day differences. And again, most families that we deal with aren't in the Rockefeller category, right? But on the East Coast, where you're talking about families who have passed down hundreds of millions, billions of dollars between 6, 7, 8 generations, how they create their dynasty trust, how they create these language is why they still have the money generations later. Because to be that public, to be a Rockefeller, a Kennedy, to have your last name be known by everybody in the community and many states over, you're setting yourself up as a target for people who try to separate your kids from their money. So asset protection for regular families isn't as convoluted and intricate as that, but you're borrowing from a lot of the same principles.
One quick question, John. What does the order of distribution mean?
Order of distribution. Which slide were we on?
I wasn't able to see what slide that we were on, but I think it was more about, for example, like if I pass away and you're my son and I want to leave you, 50%, and I want to leave my daughter Brenda, 30%. By order of distribution, what does that exactly mean? Does that mean that one person is paid out first and then another person is paid out second?
Yeah, exactly. So when you create a living trust that has that kind of language, like a distribution at age 21, let's use a basic example, then the first child that hits 21 receives their inheritance and the other child's money remains in trust until they're 21. So order of distribution, by default, your living trust is going to specify all of that. And again, you can customize your plan per child. You can set up group rules that apply to every child. You can custom fine tune it based on different circumstances of a child. If they're actively going through a divorce, like they're in the middle of it and it's nasty, you're probably going to want to make it so that they aren't able to access hardly any of their money until they're much older, until that's cleared out. So that the order of distribution is really between you and eventually your trustee. But your trustee is all they're trying to do is carry out your wishes. At the highest level, estate planning, all it is making sure that your wishes, what you want to have happen to your stuff, is what actually happens. To get away from the default system in California toward a custom individual plan that is important to you and to your family. Okay. So I'm going to go, not sure if we have other questions, so I'm going to just wrap up on spendthrift trust provisions. So again, if your child's going through a divorce or a lawsuit and their money is not given to them free and clear, there are what we call accumulation provisions in the trust that tell the trustee, if my child's being sued, don't give them any money. Hold it back, accumulate it within the trust. Money that would otherwise go to a creditor is held over, or just the spigot of money, the flow of money is turned off completely. The vault door is closed. And then somebody suing a child who's a beneficiary realizes, I can't force distributions. I can't speed this up at all. So they're going to it's promoting a settlement of the legal claim against your child. So that's one of the things we tell people. It's not just the fact that you're protecting them from themselves, but if your child gets in an accident or some other, a divorce situation or whatever, you're promoting legal settlement in their case when people realize they can't access the money that you've left them.
Quick question on that before we move on, just so that I can ask. One question that came in is regarding creditors. So does this mean that creditors are not able to get at assets? Like, for example, if you have a home and it's in a trust, does that mean that they can't foreclose on that home? Because I don't think that that's the case. I still think that the bills need to be paid.
Yeah, foreclosure is one of those things that the state gives in the state of California. I mean, most states, but especially here, banks have a statutory right to foreclose, regardless of any asset protection vehicle. So primarily what we're saying is there's a pool of money that's in your estate. When you die, by the trust container, it's going to your kids. If you If you basically put it in their wallet, there's no legal difference between them and the money that you've left them. Legally, financially, there's no difference. So if that child goes out and gets sued, a creditor gets a charging order against them, and they can access whatever your child has access to. The fire break or the firewall that we're creating through a trust, through a spendthrift trust, says that money is not theirs. It's the trustee's management. It's the trust money, not your kid's money. So we're creating a legal difference between the money that's in your kid's wallet and the trust money. There's tax returns that have to be filed. There's a different tax code for trusts as opposed to individuals. It's a real legal difference, but that's what we're talking about, protecting them from creditors. If somebody sues the child, say a child gets in a car accident, it's their fault, they're going to be sued. But if the money is in their wallet, all that's gone. If it's still in the trust and the beneficiary or child has no right to force money from the trust to themselves, then neither can a creditor, and they're going to understand that. And more importantly, the plaintiff's attorney is not going to take the case if they're not going to get paid, right? They're doing contingency work. They only get paid if their client gets paid. And if they look and say, this person's basically insolvent, there's a trust, but we can't get at it, they're not going to take the case. It's not worth their time to even file that lawsuit in the beginning. So that's one of the strongest, most powerful benefits. I mean, to be honest with you, just a basic living trust, AV living trust, is some of the most powerful asset protection provisions that you can get anywhere. You don't need to go to Nevada. You don't need to go to foreign jurisdiction trust and all that stuff. A basic living trust has a lot of powerful stuff to protect your kids from their creditors. Again, to administer an estate when somebody dies, whether in a trust or a probate, the creditors, the people who die, have to be satisfied, right? The reason that the real estate can't be, that foreclosure can't be stopped by a trust is because in California, they have a trust deed, right? So in order to lend you money to buy the house, they take a trust deed back, put it with a trustee, not your trustee, their own trustee, that says that this person defaults on their financial obligations, we can foreclose. And that has nothing to do with your living trust. Your trust doesn't stop that. And more importantly, a living trust isn't protecting you from your creditors. It's protecting your beneficiaries from theirs. That's a very important distinction. And we can talk more about that later on. So the basics of an estate planning package, we've already talked at great length about the living trust. That's your bread and butter. The foundation of your estate plan is your living trust. A pour over will, we'll talk about why that's important to have and why it's different than just a regular will. Advanced healthcare directives, financial powers of attorney. Items 3 and 4 are critically important if you're alive but you're incapacitated. You've gone to the hospital for a severe illness or lengthy incapacity, or like we talked about before, parents with Alzheimer's, dementia, other mental impairments that keep them from handling their own affairs. Items 3 and 4 are critical. And then the other one is your grant deed, putting your real estate, your real property into trust. The will that we talked about is important for one major thing. If you have children who are under the age of 18 and you die, California law requires that child to have a guardian legally responsible for their care until they're age 18 at a minimum. You want to choose somebody, what criteria, how do I choose a guardian for my kids? You want to choose somebody who is financially and emotionally stable. They don't need to be a MBA financial wizard. Most importantly, they have to be somebody who's committed to the welfare of your kids. And they would basically be doing the same job that you would do if you were them. So one of the number one things I go through with clients, and we talked about this before, if you need to choose a trustee who's a bank or a professional, they're available to help your family. So when you're trying to choose between, two potential guardians, I got a brother, he's an MBA wizard, he works on Wall Street, and I have a sister, she's great with kids, but she doesn't balance her own checkbook. It's much easier to choose somebody to manage the money than it is to raise the kids. In that circumstance, all other things being equal, I would actually go with the sister because she's going to be better with kids. And that's your sole criteria. Obviously, you don't want to choose a guardian whose own life is in financial free fall, right? Going through a bankruptcy or insolvency. You don't want to create a temptation for them where the money that you've left your kids is going to solve their financial problems. That would be illegal, obviously. But short of that, you want to make sure that your primary goal and objective is choosing somebody who's committed to the welfare of your kids who would do as close a job to raising your kids as you would. The money part can be farmed out. Raising kids can't be farmed out. There's no professional kid raisers, for better or worse in our society. So, and the other thing is that the trustee that you choose has to be able to work with the other professionals, including the trustee. I had one family came to me a long time ago. They said, well, we want everyone in our family to be involved. So we're going to have the wife's brother in charge of the kids and the husband's sister in charge of the money. And I'm like, that's a terrible idea. Unless those people are on a daily phone call in regular, consistent contact and on the same page. Never, ever, ever let somebody be in charge of your kids' money who has any agenda other than making sure all your money is available for their needs. We had one case where that was not the case, and it was a crazy amount of hardship for that family. And then the item in red, critically important, when you name a guardian, talk to them about it, right? So discuss this with your intended guardians early and often. Don't surprise them. Hey, guess what? Your brother's dead, and surprise, now you have kids. Like, don't do that. It's a I mean, it should go without saying, but I say it anyway. It's one of those things that's critical. Talk to your guardian, let them have input, let them say, hey, this is not something I can take on right now. I would love to help, but it's just not feasible. The other documents that we're going to talk about, your advanced healthcare directive. Obviously, we're still in the middle of a pandemic, and that's been front and center for everybody for the last year and a half. You want to have your healthcare documents drafted right now while you're, in good health and sound mind, but they become executed during incapacity or serious illness, right? Someone's being rushed to the hospital. So you are stating in your healthcare directive what you want to have happen, regarding life-sustaining treatment or other decisions. You're authorizing somebody else to carry out your wishes. They will always be your wishes. So you're choosing somebody who has the ability to almost act like a robot. I know it sounds weird. You want them not to exercise any independent thought or judgment, but to simply carry out what you have said and what you've written down on paper. California's default is without a writing by the individual, life support's not going to be withdrawn. Somebody can be in a coma for a long time. And if that's not your wish, then you need to put that in your document so somebody can legally carry out your wishes. Your financial power of attorney is critically important as well. It's when you are live but incapacitated, you're giving legal signing authority for your name to a third person. It can be the same person as your trustee, the money person of your trust, and it covers all aspects of your finances, whether or not it's in trust. So there are a whole bunch of parts of your financial life that aren't going to be owned directly by your trust, including retirement plans. Social Security is obviously a big component of people's net worth. That's the government's money until they put it in your wallet. So if they need somebody to speak to and it isn't you and you're in the hospital, you need to have a valid power of attorney so that they can, the Social Security Administration can coordinate with them the right thing to do with your money to make it available for you. And then lastly, deeds for your personal residence, critically important. One of the things I'm going to talk about here in California, all California, this is an important subject. In the Bay Area, it's critical. We have a lot of clients who bought their homes in Northern California in the 60s, the 70s, or the 80s, or even the 90s, who are sitting on more than $500,000 of capital gains. I mean, I've had multiple clients who bought their house in Sunnyvale in the 1960s for 20 grand. I had one client who bought their house in Menlo Park off Sand Hill Road for $50,000. So they were sitting on a couple of $1 million of capital gains. And these families are not, they're not otherwise Rockefellers, right? They're house rich, cash poor, or cash middle class. But this is one of your most important assets. So how you treat that is very important. So one of the key benefits California gives you, and also the IRS, is that if you own property as community property, husband and wife community property, and one spouse dies, you are eligible to eliminate all of your capital gains. It's what we call the stepped up basis. The thing that you need to pay attention to by looking at your deed is that if you own it husband and wife as joint tenancy, you're only eligible for half stepped up basis. So you're going to leave a lot of money on the table just on how your deed is titled. So let's talk about my Sunnyvale client. I'm actually meeting with them, the kids, this Friday. My clients, I did their trust back in 2007. The mother passed away a couple of weeks ago, so I'm meeting with the kids who administered their estate. Husband and wife bought their house in Sunnyvale in the 60s for $25,000. In 2007, they refinanced their house out of their trust into joint tenancy. They put it back in a trust. But by having it as joint tenancy, the IRS says, we're not going to give you a full stepped up basis. The dad died in 2016 with a fair market value around 2 million. It's way more than that now. So the question is, are there any capital gains owed? So the daughter came to us, said, hey, dad passed away. Mom is in a nursing home and she can never have the ability to return home. She's in a memory care facility. She cannot ever reside in their residence ever again. We'd like to sell the house because we're burning through $10,000 a month in healthcare for our mom, and they weren't rich people, but they have this asset. So the question is, would they pay any capital gains tax if they sold it when mom was still alive? And the answer is, if it was owned as community property, they would not. It would eliminate all capital gains. The new fair market value is the cost basis for taxes on capital gains, and they could have sold it on the day dad died and paid no taxes. Unfortunately, because they own the deed as joint tenancy, they were only eligible for half stepped up basis. So the net, like what's the bottom line? To sell the property, the difference in how it was titled was a 6-figure difference for that family. They would have had to come up with taxes well into $150,000 in taxes paid, just because the deed said one thing instead of another. So that's something you want to talk to an attorney about and make sure that you're getting the best advice on how to hold the title in your real estate. These next slides, got 2 slides on Prop 19 recently passed in the last election that are now in force and in place for all families in California. This is a monster change to our property tax system and regime here in California. It's worth a ton of money, and there's some good changes and there's some really bad ones. So I've included these 2 slides. And I don't want to go too far into the weeds and giving the history of Prop 13 and all these other exemptions, but these slides are here for your understanding. The benefit of Prop 19 for families, the thing that got better, is this section here, which is if somebody's over the age of 55 or qualifies as disabled, they can sell their property here in the Bay Area or wherever in California, and they can take their low property tax basis with them wherever they are in California. That's a huge change, and that's an enormous benefit for seniors. So let's see, the third line here, location of the replacement home, where do they have to buy? Previously, there were only 10 counties you could do that in under the last law. So if somebody sold their house in Santa Clara County, they were limited to like 9 other counties if they want to take their Prop 13 basis with them. The new law allows them to take that in all 58 counties of California. So that's a huge benefit for people who want to downsize, maybe move out of the Bay Area or Los Angeles from high cost of living areas to more relaxed cost of living and not raise their property taxes. So this slide here is critically important. I think it's part of your handouts. But if you want an extra copy of this, I can also email it to you. Just let me know. But this is a huge change for the good. The downside of Prop 19, the change that people are really up in arms about, is when they change Prop 58, the parent-child transfer, and Prop 193, which is the grandparent-grandchild exemption. So the old law, you could transfer your kids any amount of real estate under $1 million base value without any change in property taxes. You could have a house in Menlo Park that you paid, like my client, $50,000 for. You could transfer that to your kids at your death, and they would take your property tax basis. So they would continue to pay, $5,000 a year, and their next door neighbor's paying $5,000 a month. That's a tremendous financial difference. They've actually eliminated the complete Prop 58 parent-child transfer. What they've done is that they've limited it only to your primary residence. Previously, you could do it on second, third homes, whatever. Now it's exclusively limited to your principal residence of the child. So the child has to move into your house. You can't rent it out to anybody and make an income off of it. You can't have, you can't have anything other than one child has to move into that house, claim it as their primary residence to qualify. And it's capped at $1 million, a fair market value. So, I have a client in Palo Alto who has a child, and they were concerned about this because they paid $250,000 for their house in the 60s in Palo Alto, and it's worth more than $4 million now. Under the old law, she could have passed that to her son, and her son would pay her property taxes, which is, $3,000 or so a year. Now they're going to give you the first million at the old number, but they're going to reassess it for the 3 million above that. So he is going to go from, under the old system, $2,000 a year to the new system, $35,000 a year. And year over year, that's a big change and a big difference. So people are really, really, really unhappy about this. I got a whole bunch of angry phone calls in December, and I said, yeah, that was the law that was passed. Call your assembly member in the legislature and tell them you're unhappy that you want this fixed. But this is, as of right now, this is the law, and it's really unfortunate for a lot of people. So yeah, moving on. We want to pause. We can pause for questions. Go ahead.
Sorry, there is a ton of questions in the chat that I do need to get to, but sure. There is one that's specific about Prop 19 that just came through. They're curious if Prop 19 is retroactive, that they sold their property in 2018 and bought a higher value property. So wondering if you had any insight on that.
Nothing about this law is retroactive. It's all about the regime that's, yeah. It's basically as the regime. So people are like, well, how do I, do the parent-child transfer, before this law kicks in at March? And the answer is you could deed it to your kid, but then you're sacrificing the capital gains benefit. So there's no, in any of this, there's no easy answer for planning.
Okay, thank you. And there is quite a few folks who have either typed in the chat or sent me a direct message asking if they can have some kind of I know you mentioned you had a handout as well. So just to reiterate, because I know some folks weren't here in the very beginning of the webinar, at the conclusion of the webinar, we will be sending out a recorded version of this webinar, along with any handouts or other information that John has for you. We won't be sending out the slide deck, but we will be sending out the webinar itself, the recording of it, as well as giving you John's information in case you do wish to meet with him one-on-one. That will be an option available to you. And if you need to meet with a banker to discuss the actual trust that you may have with Patelco, that option will be available to you as well. So just know that everyone on this call today and the folks who registered but were unable to join will also be getting that same recording with the same information. So just in case you missed anything, don't worry, you will get that information soon. And for the remaining folks on the call who still have questions, I will be getting to those soon. I just want to make sure that John has time to get through the bulk of this information. Thank you. All
righty, folks. So now comes the fun part. We're going to talk about finance and estate planning. How much is all this going to cost? Because obviously that's the number one question people have. I realize I need an estate plan, but how much is it going to cost me? So I'm going to talk about your different options that you have. We're going to explain a little bit of the finance and estate planning, how much it costs. The number one thing I tell people, it's important, in fact, it's critical that you understand how much an estate plan costs is not its setup cost. It's what's your actual cost to your kids and to your family after you're gone. That's every bit as much, if not way more important than how much you spend today. So you have a couple of options. Obviously, you can have no plan. You're do-it-yourselfers, the people who think they're going to get to it and then don't. The upfront cost is free. Free is good. On the back end, they're going to pay 3 to 5% of the value of their estate in probate fees and costs. So there's an upfront savings in that it's free to have no plan. On the back end, though, you're going to pay through the nose to the state of California and to other people to administer your probate. You can have a non-attorney trust mill, right? LegalZoom is the big one. They are kind of, it's really funny because in the documents you ever see at LegalZoom, they all have 1,000,000,001 disclaimers. And one of the bottom ones are, we are not lawyers. Go consult with a real lawyer in implementing our documents, as opposed to just going to an attorney in the first place and cutting out the middleman of LegalZoom. So, other programs, We the People, other forms-driven programs with no accountability. You're not meeting with a lawyer. You're not getting advice to your individual situation. Honestly, there's an enormous near $1 billion industry out there that gets people to obsess about estate planning is about documents. And after 20 years and representing thousands of families here in California, I can't tell you enough. It's not about the documents, it's about your family. You can have an A+ $5,000 living trust that's a train wreck for your family if your family's individual needs are not accounted for. And you can have stuff that basically you write on a cocktail napkin that works for simple cases. So it really is about creating an estate plan that's custom for your family, getting the advice. The reason you use a lawyer is to get the advice about your individual circumstances. again, whether it's a non-attorney trust mill or an attorney trust mill, the attorneys who do hundreds or thousands of these a year, they crank out, everybody gets the same cookie cutter estate plan. Those are both trust mills. Those are putting an emphasis on documents and not on your family. There's a trust mill around the corner from my office, and they've been doing it for years. And I've talked to multiple people who have gone there, and the amount of FaceTime or even Q&A you get with an actual attorney is almost non-existent. You're meeting with paralegals, you're filling stuff out. You know, his name is on the letterhead, but it's barely an attorney-client relationship. It's just a form. It's not really that much more glorified than LegalZoom itself. So again, up front, there may be some savings, but we're going to talk about, I'm going to give you some very specific examples of families who had nearly unlimited liability at the end. The middle tier, the trust mills have no accountability. They don't stand behind their product at all. If you go to LegalZoom and you put something together and your family winds up in court, litigation, or probate, there's a giant mistake made that cost your family thousands, you can't go to LegalZoom and blame them. Their disclaimer says we're not lawyers. I mean, really, that's it. We'll take your money and give you some paper, but we're not going to stand behind anything. So obviously the far right column, working with an estate and tax law firm, people who know what they're doing, people who've been doing this a long time, representing families in court and out of court, who understand the entire process of estate planning and can give you tailored advice to your unique situation, right? So the upfront cost is greater, the back end cost is greatly reduced. And I'm going to give you some real examples now of people who saved some money up front and who literally bled money out of their net worth on the back end, almost unlimited in damage, because there was nobody they could turn to give them advice, and it was a big mess. So I'm going to give you a couple examples on that. You know, the no planners, again, this is your statutory probate fee. If you don't have a trust, if your estate goes to probate, that's how much it costs to administer in California a probate of $1 million estate, $47,000 to $50,000 by the time all is said and done, factoring in the attorney's fees, the executor's fees, the court fees, the appraisal fees, all that stuff. So upfront, a $1 million estate, it doesn't cost anything to not have a plan. This is how much it can cost you on the back end. So the cost of this estate plan is not free. It's $50,000 or somewhere in that range. That's the actual price they paid for their plan. I always love this one. How hard can it be to do it yourself? Well, we're about to find out. This was a fairly straightforward estate, $500,000 estate, one house, couple of bank accounts. The downside, it was a cash business. He owned a cash business. His financial and tax records were a train wreck. Had to recreate that from scratch using forensic accountants. This guy did some kind of trust, I guess, document from, you know, his buddy, his drinking buddy, went to the internet, Googled trust or whatever, did some cut and pasting work. You know, personal property, I give my motorcycle and equal shares to my two kids. How does that work? I don't know. Selling a cash business. The beneficiaries in that estate hated each other. They literally, this was like a rope and a tug of war to them. It was another gratifying opportunity to try to kill each other, honestly. So they wound up spending on the back end. Again, his upfront cost, $50, $100. His back end cost, you know, $15,000 in legal fees, CPA fees, $40,000 and up to get the stuff in order for the IRS and for the beneficiaries. So again, the back end cost for this modest estate, $55,000, a year and a half to administer. That's an expensive estate plan. Even though he got away up front, going real cheap while he was alive, his kids and family paid dearly for that one. This guy that I meant to get around to it before I died, very common scenario, had a probate case that had $6 million, no will, no trust, nothing, had no kids, grandkids, no direct descendants, no obvious people the money to go to. That wound up in 3 years of litigation, where the property wound up being split between first, second, and third cousins. Third cousins wouldn't know the man if he mugged them on the street when he was alive. Like, I don't even know who this person is, and they got a couple $100,000. Like, every time I think about that case, I'm like, why doesn't that happen to me? Like, why don't I have somebody I've never met leave me a couple $100,000? But again, that's the sort of insanity that you get from intestate cases when you aren't the one in charge of deciding who gets what. Another case in the Santa Cruz court system, this gentleman had $1.7 million. He had a will but no trust. He left half of it to charity and half to his elderly relatives. Again, no kids. That wound up in years of court cases, more than $70,000 in administrative costs. The charity was badgering the family. They hired their lawyers to go after the other family members. That was a train wreck. So again, how much an estate plan costs is not your upfront cost. It's what everybody else pays to inherit your money. This is probably should be taught. Yeah, go ahead.
John, real quick, sorry.
Yeah.
One question that did come in that does relate to this. They're wondering what kind of your definition of a trust mill might be.
High volume, low contact. If it's run by if there's an attorney's name on the door, it's usually the seminar guys. You go to a rubber chicken dinner and you get sold an annuity and a bad dinner, and then there's a trust involved. There's a whole, it's not as common now, obviously due to COVID, but when we started our industry, my business partner, he got into estate planning. He was actually working as a CPA attorney. Wasn't thinking about estate planning. This was way back before I even met him. And his parents and their friends would go wandering off to these rubber chicken dinners and come back with some kind of trust. And it was it was a nightmare. And mostly they were being sold financial products that were also atrocious. But here they are thinking that they had something that was competent, that everything was a disaster about it. So the definition of a trust mill is extremely high volume, extremely non-existent or low contact with the attorney. They don't delve into your situation, fill this out, sign here and leave. The trust mill that I was telling you about, that's not that far from our office. You're watching a video and then you're talking to I think it's his wife or daughter, is his paralegal or whatever. And I think he shows up in the signing and that's about it. And the documents are terrible. But the characteristic of a trust mill is high volume, no advice, no customization. You're getting cookie cutter, rip off the shelf, same garbage. The worst ones, like I said, are the ones where there's some financial garbage being sold to them. But effectively, you're not getting something that's tailored to your family. It's a long definition, but that's what a trust mill looks like.
And then, and thank you for that. And then in that same breath, I'm wondering if your estate is less than $1 million, is it still subject to probate?
If your estate is less than 160,000, you might be able to do a small estate administration. If it's over 160,000, not 1 million, it's going to probate. So the threshold for probate in California is it's actually increased in my lifetime, or in my career rather. When I started, if your estate was more than $50,000, it was going to probate. Now I think it's 162. It's adjusted for inflation, so it changes yearly. But if it's like under 160, 170, it's going to, if it's over that, it's going to probate.
Okay, will do. And then there's a bunch more questions in here, but do you want me to wait until kind of closer to the end?
Yeah, I'm just gonna blaze through a couple more examples.
Okay, will do.
Obviously, this is a grandiose example that doesn't apply to most people, but there's some fundamental things that are going on that apply to everybody or a lot of families. So this one, I joke, my business partner, is his litigation case. Should be taught in law school and textbook because it's honestly a case example of absolutely everything that could possibly go wrong in a family. And in my opinion, I'll talk to you about this at the end. The real train wreck was not just the money, the litigation, the fees, and everything else. The train wreck to me is that the family was destroyed over this inheritance. So this gentleman owned a lot of land, a lot of real estate in San Francisco, 28 properties. He was in a blended family, so he had a second marriage. He had his kids from his first spouse. And whoever was doing his taxes said, don't spend a lot of money on a lawyer, just go over to the trust mill. I don't know, it wasn't LegalZoom, that didn't exist then, but it was some equivalent. Just go to a trust mill and crank it out. And so he did, and they weren't lawyers and they didn't give him legal advice. And in his trust mill document, to its credit, it said what he wanted to have happen. He said, I want 4 real properties, 4 houses to go to my second wife. And I want 24 to go to my kids and sister. In reality, when he died, the wife goes to a big law firm in the Bay Area and they pull up all 28 deeds, and every single one of them said the same thing. This property is owned husband and wife, joint tenancy, right of survivorship. His trust was empty. Everything went to the wife, the kids got 0. The joint tenancy is one of those things that is extremely powerful. It's the bane of our existence because nobody knows how it works. Everybody, a whole bunch of people have it, don't know how it works, and don't know about the power, don't understand how it impacts them. So let's talk about 7 years of litigation, hundreds of thousands of dollars in legal fees, family no longer speaking together. And that's the real, like I said, that's the real train wreck for this family. Just because there's an attorney involved doesn't mean it's not a trust mill. So this lady changed her documents about 5 times in the last 8 years of her life, left a whole bunch of money to a family member, but wound up in a ton of litigation because she did not have attorneys that were looking over her system, that were looking over things to give her guidance and advice. So this one wound up in litigation. At the end of the day, I mean, my client inherited a bunch of money from her aunt, but still wound up 2 different lawsuits, $150,000 in fees and settlements. She got her money at the end, but she went through hell to get there. So we emphasize, spend the money up front, get it done right, use attorneys who stand behind their work, not people, it's not a hit and run situation like LegalZoom or whatever. It's not about the documents, it's about your family, making it work to your individual tailored results. It's relationship driven, it's not document driven. I want to talk to you briefly about our, we talked about this before. We offer a special plan, exclusive offer for Patelco CU members. Melinda and the other wonderful people at Patelco will explain to you how this works. If you're a member, our normal plan price is $2,500 for the living trust, the wills, the powers of attorney, etc. This is exclusive to Patelco members, and it is $1,500. So it's $1,000 savings for you and your family if you want to work with our law firm to put in place a basic estate planning package. And so there's my phone number. That's my direct line. And if you have any questions, we'll be happy to help.
And along that same line, I'll chime in here just a little bit, John. Mm-hmm. If you are not a Patelco member and you're thinking, okay, well, I want to get the discount, and and maybe you even want to have your trust here with Patelco, that is an option for you. So just know that you can open up your membership with us very simply, either today after this call. Anytime really, you can go online, call our 800 number, or come into a branch. And then we also have our virtual service hours this Friday. So from 11 a.m. until 3 p.m. on Friday, you can actually join with us in a virtual branch environment, which is just like this. You'll be receiving the link to that today, along with the link for the recording of this webinar. So just know that you are welcome to join at any time in any manner that you so choose. And then, did you want me to go into some of the questions that we have? I have a ton of questions in the chat.
Yeah, actually, what I have to, I just got a warning that my battery's about to die on my computer. So I have to flip a switch because I forgot when I turned off the light in this room, it killed the electricity in my computer. Give me one split second. Just want to make sure it doesn't die on us while we're going through Q&A. I got that warning at the end of the summer. I'm like, oh man, I've been talking for too long.
No problem.
Okay. That should do. So yeah, let's do some questions, Q&A.
All right. So the first one up is, what will happen to my living trust after I divorce and remarry? So for example, my ex and I created a living trust and will when our kids were little, but they're all adults now, and I've been divorced for over 10 years, and I'm now remarried, and I don't have a current will or trust. What's next?
Okay, so it's couple of items there. Number one, when you go through a formal divorce/dissolution process through the courts, it effectively, in real terms, terminates most of your estate plan. It would terminate your trust at the time, or at least suspend it. But it's extremely important that you put together a new plan today to take care of how your family is today. So powers of attorney, if you had an ex that was your power of attorney, that all is suspended and terminates through a divorce. So those documents become very problematic. There, it may still be a power of attorney, but there's no one in charge. So you absolutely want to update your trust. You absolutely want to update. I mean, I had one lady who came to me, it was about 10 years ago, with her mom's will. And she said, this is the only will I could find for my mom. And it was like 15 years old. And it listed her ex-husband, and like they've been divorced for like 8 years. Um, and then she's like, but my mom tried doing the will process on her own. And she handed me basically a legal pad with her mom's, handwriting. And I said, this isn't, California allows handwritten wills, but this doesn't meet the criteria. It basically becomes kind of like a diary, unfortunately. So then you have to go to court. You have to, basically throw out the other one, and it's going to wind up pretty much like you don't have a will or trust at all. So I always emphasize that's one of the key reasons to update your trust or your estate plan is family changes.
Okay. And then another question is regarding retirement plans and money in different states. So let's say that we have a retirement plan in Idaho, and then we've got another one in Florida, and then we have money in accounts in different states or property in different states. What then?
Yeah, that's one of the number one reasons to have a trust is if you own, especially real estate in other states. If you die without a will or trust and you own real estate in multiple states, you get to experience the joy of probate not only in California, but every other state that you own property. So they're called satellite or ancillary probates in the other states. So your primary master probate is set up in the state that you live when you die, but then your executors, your family, gets to open a probate in every other state in America where you own real estate. And it's there. It's a kind of a, what's the word? I wouldn't say it's an express, but it's a lightened version of full probate. But it basically administers it according to their probate, just to put it back in California's probate. That's a disaster. So having a trust, you get to skip all that, put all your accounts into it, put all your real estate into your trust. You can own real estate, LLCs, partnerships, whatever, in all 50 states. All you need is a trust in the state which you live.
Okay, that's perfect. And along those same lines, would it be the same person who's in charge of distribution of that estate when that time comes, or would you need one person for each state, or
one trustee? All you need is one trustee to administer your trust. They can hire professionals, accountants, attorneys, realtors, brokers, appraisers, and wherever they need to. That's one of the neat things about trusteeship. They don't have to do all the work themselves. They're allowed to hire professionals. So if they do own real estate, if you do own real estate in other states, all you need is a California trustee. Then they have the legal authority to go out and hire other professionals to get the job done.
Okay. And then the other question that came in was about being a trustee to someone who's not related to you. So this gentleman said that his neighbor actually asked him to be his trustee. And so he's wondering, what does that look like for him, and what is that process, and is that something that that he should even think about doing?
In my opinion, that's not really something you want to do too much. You can kind of do it as a one-off if you're related to the person, but like I said, in California, they highly regulate who can be a trustee for somebody who's not a family relation. That's, again, there's like, if you watch, there's been different, it's not 60 Minutes, but there's other news broadcasts that talk about the problems in other states, Arizona, other states where they don't have any regulation. Anyone can be a trustee for anybody. Like you can actually ask anybody unrelated, and they can do, in Arizona, they had one lady who was doing conservatorships and guardianships for elderly people. She had like 4,000 clients and she had no staff or anything. It's like she hadn't talked to these people in years. It's horrific. Oh. And at some point they're going to have regulation on that. But California and I think New York State were like first two states to put in the probate code. You were in the business and professions code, more importantly, that if you're not a licensed professional fiduciary, it's almost impossible to be a trustee for somebody else who's not your biological relation. They just don't want it.
Okay. Okay, that's good to know.
Plus, it's a really thankless job.
I was going to say, I wonder how much you get paid for that, because I wouldn't want to do it for free, that's for sure.
Well, even with money, I've told people, it's really funny. I talked to a court staff member once, and I said, somebody was like fighting to become somebody else's trustee, like a neighbor or whatever, and they had kind of had a distant family relationship, but I was like, she was really fighting to be trustee, and I went to the court. I was like, have you ever known anybody who really wanted to do this but wasn't trying to do it for a bad reason? And she's like, nope, nobody wants this. Nobody really wants this job. The people who are like, yeah, I really want to be manage somebody else's money, they're like excited for it, is somebody you need to keep an eye on. That's why the law was
Yeah, it's
written.
probably a red flag. Yeah.
Yeah, I mean, it's always like helping people out, but if somebody else comes along, and you're like, sure, I was just doing it because there was no one else to help. And now that the courts appointed somebody who, is a professional, I'm happy to step back. In this specific instance, they weren't even willing to do that. They were like, I have to be the person. Everyone's like, whoa. I think there's some financial entanglements there, and I think there's some other stuff that the court needed to the investigators had to take a closer look at.
Yeah, that sounds like it. And then another question that came in is, if you die and you don't have a will, you don't have a trust, you're not married, you don't have kids, who does the state decide to give your estate to? And I know you kind of mentioned earlier in that one example that there were cousins coming out of the woodwork, just trying to stake claim in the property. So what's your status on that?
Right.
Will the state try to find somebody?
Yeah, I mean, kind of. it's a unique situation. It does happen. The legal definition of who inherits your estate, if you haven't named anybody, is your heirs at law. And if you have no kids or grandkids or direct lineal descendants up or down, your heirs at law, that's a legal term. So that has to be defined. Who is legally allowed to inherit from somebody else's money has to go through a court process for that to actually happen. So the example I gave in my seminar, the reason it went through 3 years of litigation is everybody lawyered up and said, I get more money, I get less money. And these are like, again, first, second, third cousins. These are not these are not siblings, they're not parents or grandparents. And so to duke it out in court to figure out who gets, it was a very large estate, so everybody wanted money. So it made sense in their mind for everybody to get their own lawyers. If you don't have that kind of situation and people aren't fighting over the money, the only way that it gets done is somebody has to open a probate. Somebody has to go to court and start the paperwork. If there's no one to do that, it's going to kind of be a mess, and it's going to, it may float around. Creditors, weirdly enough, can open probates if there's literally nobody else to do it. We have had that happen. They try to jumpstart the process by filing to be executor, which is, obnoxious, but they're trying to get the ball rolling. But like, if nobody knows about your estate and nobody's ready to open it or go to court and deal with it, it's just going to sit there and float until there's a fire, a legal or financial fire. House goes into foreclosure. Someone's got to deal with that. Well, who gets the money? The court determines all that. There's a whole process for determination of heirship, who is legally determined by a judge to inherit money. And so that case that I gave as an example, it's an extreme case, but I use it because it's the default for anybody who doesn't have an easy list of beneficiaries.
And then, so along that same line, I'm wondering, so one question that I did receive is, let's say you're a married couple, early 30s, you've got no kids, but you recently did buy a home and you assume you don't have too many other assets, but I think you might be surprised to the person who sent in this question. You probably have more assets than you think you do. Sure. But they're wondering, do they need a trust? Can they just deal with a will? Or is it more that they need a trust and they won't need a will? What would you recommend for that couple in particular?
Sure. So first, again, if your estate's over $160,000 in value, you need a trust, in my personal opinion. Obviously, I'm an attorney, and I've dealt with the legal system. So real estate is one of those things, obviously, because it's California, where your equitable interest is usually north of that threshold, or the value of the house is north of that threshold. I've had one case in all my years that actually had real estate, and it was undeveloped land out by Yosemite, and it wasn't valuable. It was just land. Husband and wife got divorced, and neither one did anything with their property. And so they, it was a parcel of land. Each parent died, leaving their half to their kid via intestacy. But that did need a trust, but for any other estate over 160, 170, I would recommend it. Again, it's not just to avoid probate. It's also for the easy centralized management of your affairs. If you're incapacitated, if you have a substantial illness, when people get older, they have long-term mental incapacities. They're in a nursing home or a memory care facility. You want to make it as simple as humanly possible for your kids or other fiduciaries or other family members to get their arms around your stuff. So even if you don't have kids, even if you don't have a giant estate, in California, real estate puts you into probate. So I would, I would definitely recommend a trust.
So then another question that we had for item 5 on the basic estate planning package that you mentioned, what are the pros and cons of putting a child on the property title or the property deed?
Depends on how, well, a couple of things. One, you're going to have to figure out how that's defined. Putting them on the deed, that's in real estate being so valuable in California. Deeds, again, I've been doing this 20 years, been representing thousands of families. I've seen literally every possible combination of grant deed or whatever deed you could possibly imagine. It depends on the language you use. If you say, I, dad, own this property as joint tenancy with my son or daughter, joint tenancy is so powerful. If your son or daughter gets in a car accident or they get sued, you're going to be out on the street because that property is as much theirs as it is yours. Joint tenancy is one of those crazy things that everybody who has it has no idea how they got it or what it means for them. So putting a child on a deed is a good way to lose that property. It's also a mess, like I said before, for capital gains and for taxes. Again, for people who've owned real estate in the Bay Area or California for a long time, and the basic, $500,000 exemption or $250 is not enough. Giving, either gifting it to a child or owning it as joint tenancy or making them a co-owner could impact your capital gains. It's going to impact potentially your property taxes. Even before Prop 19, we had somebody, a family in Oakland where a gentleman added a bunch of family members as joint tenants to the property. And one of them was a grandson and he didn't qualify for the grandparent-grandchild exemption. Alameda County specifically has like a whole audit unit on deeds for property tax. They are probably, in my opinion, the most aggressive county when it comes to collecting it. They are so fierce and just going after it. And so this guy recorded a deed. All he did was add a grandson to it for 15% or whatever, small percent, and they reassessed it for that portion. They're like, no eligible exemption, pay us the money. So a trust gets you away from that. You don't have to deal with any of the downsides of that. A trust is going to give you all the benefits of lifetime management, but adding a child to a deed as joint tenant or some other combination, there's always trade-offs, and usually they're not great.
Okay, and that I think that kind of helps answer the next question that I got, which was, How does a living trust protect and how does it work? How can it be executed? Which I think that you did kind of go over in some of the presentation, and I think that you just kind of touched on that right now.
Yep.
The other question was, does this AHCD have to be notarized or in a proper form?
The healthcare directive?
Yes.
Yep, it definitely needs to be notarized. I mean, some of the older ones you do witnessing. I do notarization just because it's always easier to get a notary than 2 witnesses or whatever. But yeah, all the legal documents we talk about today have to be notarized.
Okay. And then
excuse me, the one exception is the wills, because wills are older than trusts and they have to be witnessed by 2 people. Watch you sign it in California.
Another question that I received is they want to know if you belong to the ARAG. I don't know what that is. So
yeah, we do. Yeah, I've been with them since 2009. We can talk. I don't want to bore everybody with that, but we've been with them since 2009. And so, yeah, you can absolutely send me an email.
Okay, perfect. Let's see here. I'm going to scroll down here. I know we have some more questions. You already answered that one about the $1 million or less. If you have a living trust already, do you need a will?
Yes. We talked about it briefly. So if you have a living trust, the will does 2 things. Number one, if you have minor kids, that's where guardianship is listed in your will, not your trust. Because even though you've nominated a guardian in your will, if you're gone, the guardian still has to go to court to have the guardianship established, and they take your will and file it with the court, and then that's your instructions on what you want to have happen on the guardianship. So the benefit of a pour over will, 1, that's where guardianship is listed, and then 2, it's a safety net. We call them pour over wills, because if you have any asset that you forgot to put in your trust during your lifetime, when you die, it pours over into the trust after you're gone. So even where people have trust, having that as you don't want to have to use that. You want everything to be fully funded to your trust while you're alive, but it's a safety net to keep those assets from going to probate.
Okay. Another question is, what if there was a will but no trust? Land property was under 100,000 that was left to me and my sister. There's no deed for the property. Where should I start to get help with this? And do I need probate?
The lawyer's answer, it depends. I mean, the place you start is the county the real estate's owned in. You go to the recorder's office and they have a deed. Somebody has a deed. So if you can identify the property, the assessor's parcel number or whatever, you want to start with the county where the land is or the real estate exists. They're the people who have jurisdiction over it. So you can get a copy of the ownership deed from the county. Every single, I mean, I can't say with 1,000% perfection, but it doesn't exist to have real estate and not have a deed somewhere. So you may not have it, but almost certainly the county is, unless it's like some remote part of desert out by Bishop or whatever, where literally nobody has anything on it. But barring that, the county's going to have the records. Start with the county, pull up the record. How is it titled? How much is it worth? And then meet with an attorney and figure out if it fits under the exemptions. If it's joint tenancy, you don't need anything. You don't need any court involvement. If it's if it fits on the small estate affidavit provisions under 160 or if it's 100,000, you still have to fill out some paperwork depending on what it is. You're either going to do it with the court's help or without the court's involvement rather. So it kind of depends on the overall circumstances of the estate. But the small estate affidavit will not work if you have other assets going through probate and so forth. So best is to talk to an attorney about that to get more specific advice to your case.
Okay. The other question is, if you already created a trust with a quote unquote trust mill, it's probably not looking like the best quality to me. And I want to now switch to a more reputable firm. Do I have to start over completely, or can you carry over some of the previous documents to the new firm?
Two things. One, it's not a start over. What in our industry it's referred to as a restatement. A restatement keeps the original date of the old trust if you have any assets in that trust. So if you had a trust mill document or an old trust or whatever, it's obsolete. If you have real estate or something else titled in the trust, it's a restatement counts as a 100% amendment. The only thing it keeps is the original date. And the primary reason to keep the first date on your trust from when you first set it up is so that you don't have to do anything on the deeds of the real estate or anything that's in the trust. It remains there. So all you need to do is focus on the parts of it that you want upgraded. And then a restatement will replace the old one with a new one.
Okay. And then one person asked specifically if you can just kind of briefly explain again about property owned by joint tenancy by two siblings, for example, a brother and a sister. Thank you in advance.
Yeah, joint tenancy, I have a couple articles on our website about it. Joint tenancy is the bane of our existence for estate planners. We want everything buttoned up. We want stuff that's logical, that makes sense, that doesn't have downsides for our clients. Joint tenancy, basically, I called it a legal fiction because it doesn't exist mathematically, that two people own 100%. That doesn't exist in the math world. In the legal world, it does. So two joint tenants each own 100% of a piece of real estate if they are joint tenants. If either joint tenant gets sued or loses the property, they own all of it, they're going to lose all of it, right? So we get this all the time. They're like, oh, well, little old lady has, grandson and he's the only beneficiary of her will or trust. Why don't we just add his name to the trust as a joint tenant? Well, that's a mess. If he goes out and gets sued, grandma's going to be out on the street. She's going to lose everything. So a joint tenant, two joint tenants or more equally own 100% of everything. So subject to both of their creditors, can lose everything. The other thing about joint tenancy is that it only works usually once. And what I mean by that is if it says, parent child as joint tenants, when dad dies or mom dies, when parent dies, it becomes the property of the next person. If they don't do anything, it's going to go to probate. So all it's designed to, all joint tenancy is designed to do is to get it to the other joint tenant. You cannot give away your half a joint tenancy. You would have to break it up into the other default, which is tenancy in common. Because joint tenancy, again, does not exist outside of everybody owning 100%. That's literally what it means. So if I own half and my brother owns half, then effectively we need to be tenants in common. And on a deed in California, tenancy in common could be any percent. I can be 2%, my brother can be 98%, any percentage that you like. There's no percentages in joint tenancy. It's everybody owns 100%. With joint tenancy, you can't leave it to anybody when you die except the surviving joint tenant. That's basically what it means. Joint tenancy is a will substitute. It's designed to replace your estate plan. So if you die, your joint tenancy is going to the other joint tenant, not your kids. So if you don't want that, you need to terminate the joint tenancy, create a tenancy in common, and put your ownership percent or whatever into your trust that goes to your beneficiaries. Because right now, all it does is put it to the other person on the deed.
So that actually brings me into the next question rather seamlessly. So if you're not married, you are a homeowner, and you've had a partner for over 30 years, does that partner have the right to your home, or does it go to your son, who is now an adult? And if so, can the partner fight the son for the house?
Well, people can fight anyone for anything, for any purpose. Number one, that's a classic example of why you need an estate plan to get it away from defaults. Number one, California does not have what we call common law marriage or divorce. Other states do. The Confederacy, the South, Arkansas specifically. If you've been living with somebody, holding yourself out by community standards as a married couple, I think it's 7 years. Don't quote me on that because I'm not an Arkansas attorney. Then you are the same legally as you are married. California doesn't have that. So no matter what you want to have happen, you need to put that into writing in your estate plan so that nothing else happens, right? If you leave it to chance, it could very well become something, a rope and a tug of war between them later.
Okay, and then there's so many questions in here.
Sure.
How does the paid trustee know that you passed away and to initiate the trust? And from what I remember in my banking days when I used to work in the call center and I used to manage calls like this, we needed to have proof that the person who owned the trust actually did pass away. So we needed a proof of a death certificate, and I think we needed a most recent copy of the final will. But I want to give that over to you and make sure that that's still the case.
Yeah, how anybody, it's kind of a, what's the word? There's an art and a science to it. So the science is the legal documents and the terminology. And the art to it is that there are people involved, right? In any estate plan. And so I emphasize every bit as much the human element of this, if not more than the documents. So like when we talk about healthcare directives and things like that, I always emphasize to people, you usually 99% of the time, you're creating your legal documents when you're sound mind, peaceful, relaxed, whatever, you're able to think things through with your attorney, but when it comes time to execute it, usually there's some chaos, right? Someone's being rushed to the hospital, got to find the will, got to find the powers of attorney, all that stuff. So you want to make it as seamless as humanly possible for the people you've named in your document, trustees specifically, to get their hands around your money and your estate for the benefit of your beneficiaries. You want to make that as seamless as humanly possible. You don't want them running around. You're in a coma and they're running around bank to bank to bank getting their name on things. That's a mess. They don't want to be doing that. You're wasting time and money. It's just a disaster. So I preached everybody comes in our office. When you're setting up your estate plan, now is an excellent time to consolidate your affairs, have fewer bank accounts, have fewer financial accounts, get rid of anything that's not absolutely necessary in your estate, because you know how to manage your affairs, other people don't. So when the time comes, you got to make it idiot proof. I hate saying that, but it's true. Make it idiot proof for the next person to come in. I had one client, dear client. I loved him. He was just a great person, great family. He was a financial planner, had a very large estate, a lot of money. When he was in his 80s when he came to me, and he had stuff at 4 different financial institutions, custodians, managing his money, different investment partners and whatever, because he was a financial planner. And we'd sit down. And I'm like, why do you do that? And he's like, I like playing it off against each other. I want to see who has the best returns. Who's got the hot hand. He was like really excited about it. And I was like, excellent. But, the corollary is nobody in your family knows anything about this. They had a very, very, very extremely old school Irish Catholic family. Father knows best. Nobody else has any understanding about any finances at all. Dad balanced everybody's checkbook. There was, he had a financial literacy on a 0 to 100 of 1,000. Everyone else is 2. And I said that to him. I'm like, you're the oldest one here. If you don't live forever, and it's likely that you're not, do you really think your kids are going to appreciate having to deal with 4 different financial custodians? Do they know?
Yeah.
Do they know where things are? Do they know how long do you want them to spend getting their arms around it? And he's like, oh, that's a good point. I'm like, do you think they can do your level of playing them off? He's like, absolutely not. So I said, great, pick one, pick your favorite custodian and move your money there. And so he did that. He wouldn't have done that like in his 50s or 60s. But at the what became the end of his life in his 80s, he passed away a couple of years later. He really took the value to that to heart. And you don't have to be in your 80s to consolidate. You want to make it seamless. That's the human aspect of this, right? So how your trustee knows that their services are needed, have a network of people who can get them the documents, have other people who can call them, let a bunch of people know, at least at the minimum, where your trust and wills are, right? If you're going to keep it in a safe deposit box, let everybody know that it exists and how to get the key and all that good stuff. If you're going to keep it on your computer or some other place, let other people have a copy of it. Let your trustee have a copy of it. What you don't want is you're in an ambulance going to the hospital and other people are stumbling around your bank accounts, and it's after hours and customer service isn't picking up. I mean, don't do that to people. Make it as seamless and frictionless as possible. So communicate. That's from day one. Communication is something that we really harp on for our clients, because the old school of estate planning, when we started the industry in the 90s, the old school is mom, dad set up a trust, tell nobody about it, button the lip, nobody knows a thing about it till somebody dies. Guess what? Big surprise. And that increases friction. That increases lawsuits between the kids. People don't like being surprised. They're dealing with personal grief of a loss of a family member. And oh my God, I need to now figure all this other stuff out. So communicate, be transparent to the extent possible. You don't have to tell all your personal details to everybody. But if somebody's a trustee, they need to know that. They need to know how to access your documents. And everybody else around you, your next of kin, knows how to pick up the phone and call them and say, hey, mom or dad went to the hospital. It's time to do your job.
And then, so another question that came in is, my elderly aunt lives in another state and she really needs to start a trust and or will immediately. Can she use you even though you're a lawyer here in California?
Nope, I'm licensed here, California. Okay. And as I tell my wife, she's like, well, what if we moved to another, state? I was like, well, I'm an attorney in California. I flip burgers elsewhere. Like, my powers, such as they are, don't go outside our 58 counties. So I'm legally not allowed to represent somebody in another state. I can and have made good referrals to other wealth counsel attorneys, other people, of a similar experience level as us, who would do just as good a job in another state. But like, that's states are very protective about their borders when it comes to legal stuff. For instance, Texas, I can't even prepare a deed. If I have a California client who owns one piece of real estate in Texas, I'm not allowed to prepare that deed because that's considered the practice of law in Texas, and they'll come after you.
Wow, that's interesting.
They like guarding their borders. That's a big deal to them.
I'm sure,
California is the other end of the spectrum. They're like, anyone could do a trust mills, guy in the corner. Like, it's a mess over here, but.
And then one gal wants to know, if she works with you, can you also work with her mother? Which I assume, you absolutely could. Okay. And then, is it possible to change the language on a deed for a home that is owned by a husband and wife? So I'm assuming they want to go from joint tenancy to tenancy in common.
Or whatever it is. Yeah, you just have to create a new deed, execute it, sign it, notarize it, file it with a recorder.
And then along that same line, so they said, my brother and I are co-owners on a home. We all own our own homes as well.
Mhm.
What is the best title to pick, joint tenancy or community?
Between siblings, there's no community property for siblings. It's a couple thing. I don't know your family and your exact specifics, but at a threshold, joint tenancy, like I said, is rarely a good choice for most people. I mean, there's a handful of cases where it works. One little old lady, one child, and they're a safe kid, and they don't want to have to, little old lady has nothing but one house, no money to pay an attorney, and wants to just give it to them. I mean, it's not a train wreck there. But when siblings co-own property as joint tenancy, I advise people in that circumstance all the time. You need to sever the joint tenancy, create a new deed. At a minimum, it has to be tenancy in common. But then you can put your piece of it into your trust. But all that impacts your sibling, so you want to be on the same page that this is going to happen. If you do anything to a joint tenancy deed, like create a trust or whatever, that it's called severing the joint tenancy. It ends it. If there's anything other than person A, person B as joint tenants, you've severed it. So percentages, trust. So if you say, one deed says joint tenancy and the next deed is I put my part into trust, you sever the joint tenancy. There's no existing joint tenancy after that. It's a very strange, kind of archaic way of holding title. And it's extremely powerful. In our industry, it's called a will substitute. It's supposed to replace your estate plan. And that's why it's so powerful, because it does it all the time, whether or not people want that to happen.
Okay. And then, so for the property that's already in joint tenancy and in RLT, which I'm not 100%
Revocable living
sure
trust. Yeah.
Okay, thank you. One spouse passes away. Does the other get the step-up tax basis?
Whew. So yeah, that was the example I used from my Sunnyvale client. If the property is joint tenancy, the government's going to give you half the stepped up basis. If it's community property, you get 100% stepped up basis. I've actually had to I've researched this, gone to the Treasury, United States Treasury bulletins from the IRS, how they handle this for this family and a couple others. The IRS defers to California law on whether or not, if the deed is, in other words, if it's just the deed that says joint tenancy, but nothing else does, and they don't really have any separate property, there's a case that you could make, even if somebody died joint tenancy, that you get the full stepped up basis. The example is my Sunnyvale client, right? So these people died, now both have passed, and they were together for 60 years. One spouse met in high school, got married right then, never had a single dime, penny, or anything outside of the marriage. That's the actual textbook example of community property. The fact that their deed said something else is a deed mistake. They did not intend to hold anything as a joint tenant. So you could fight the IRS on that one, and you probably would win. But the only way to do that is to sell the property, claim the full exemption, wait for an audit, then make your case to the IRS and audit. Not a lot of people want to do that, because the penalty, if you lose, is you owe penalties and interest plus the money. So it's kind of a, what's the word? It's a point of no return. The IRS doesn't do theoreticals. They don't involve themselves unless it's something truly revolutionary, unique. They're not going to give you a tax opinion on anything. And so, well, Mr. IRS Commissioner, is it this or that? They don't care. Their answer is we win either way. So just go ahead and sell it, and we'll see what happens. And then if you want to spend your time in an audit and prevail, there is law that says, if you can demonstrate everything else they own is community property, they have no separate assets. Everything that they've intended to do is community property. They're just unsophisticated people, and they didn't mean to do it because somebody put a deed in front of them. That's this family. They are if ever you have a winning hand with the IRS, this family is it. And their kids are I don't want to go to audit. I don't want to have to deal with that. I don't want to look over my shoulder. It's a 6-figure tax bill plus penalties and interest if we lose. We're trying to take care of our, elderly mother in the hospital for the last few months or years of her life. We don't want to spend a bunch of time in tax court. That doesn't sound appealing to us. So the answer is, it depends. Okay. Sorry, that's the lawyer's answer to everything. It depends.
And so along that same line, and I think that you did kind of touch on this earlier, how would you find out if your current property has you and someone else listed as joint tenancy? Is that something you need to go to the county recorder's office and just kind of
Yep.
take a look at the deed?
Yep.
Okay.
The deed,
All right.
the deed is everything in California. I mean, all states, but how a deed is titled is absolutely everything.
Okay. And then if you're currently in the refi process, what would be good language and a good way to go about seeing in a closing statement whether it's joint tenancy or tenancy in common, just so that they can audit what they have, and can they change that during the refi process?
I would not do it during the refi process.
Okay.
Because that's just one thing your title company doesn't want to have to hassle with. When you purchase, that's the time to do it. In a refi, the two things that, and I've actually done, by the way, I forgot to mention this, we have like a video newsletter we send out to people, a couple of videos a month, and I'll add the people, our attendee list to that. One of the videos I shot on that are problems that we've seen over the years on that specific issue, the refi process. But the two problems we've seen that people need to be aware of, and when they have a trust, is if you refi it, you need to make sure the title company puts it back into your trust. So I had a lady in Orinda, she did a trust in 1999 and refinanced her house in 2000. I spoke to her in 2019, I think it was, and her house is not in trust. So I pulled up the history on it, and I said, oh, if they took it out and never put it back in, like you could hear, it was over the phone, you could hear her jaw like drop. I'm like, your $2 million house has been out of your trust for 2 decades because the refi process was a train wreck. And the other thing is the example I gave from my Sunnyvale people. They take it out and they don't do that process right. So.
And then one question, and I haven't heard of this before, but I'm assuming you probably have. There is an act called the Homestead Act, and they're wondering if that still protects your property residents, your primary residents, from liabilities.
Yeah, I mean you're going closer to bankruptcy law. So the theoretical answer is yes, with a whole bunch of limitations. So like in Florida, for the longest time, your personal residence was exempt in bankruptcy or anything else for the full amount. $3 million declare bankruptcy. I still got my house. Every state's bankruptcy law. I'm not a bankruptcy lawyer. I don't give advice in that area. So Homestead it gives you something, but I'm not an expert in how much or how strong that is for each circumstance. So we had one case, from 2008 where a lady husband passed away, and he owned like a bunch of real estate in Phoenix. And in 2009, when the market evaporated there, they owed the bank about $1.5 million when he died. And the bank was like merciless and coming after it for the money. And they're like, should we just deed the house over to them? I'm like, I'm not a bankruptcy lawyer, but you need one. Maybe you move from San Diego up to your house. Their house is in San Jose. That's why they called us. Maybe you move into your house and you claim that as your personal residence and get your homestead exemption, all that good stuff. But whether or not that's an effective technique, you got to leave that to a bankruptcy lawyer. So the answer is, yeah, there is some protection, but I'm the people that test the limits of that every day are bankruptcy lawyers, because that's what people do. That's the number one way, whether through litigation or some other avenue. People wind up in court, they declare bankruptcy, and then the homestead gives them something of the equity of their house as a protection, but the rest is going to be gone.
And then, so this is kind of a convoluted question, but it's very relevant in today's modern family life. So let's say, for example, you are divorced and you want your wife to be the primary beneficiary, your ex-wife, to be your primary beneficiary of your estate. Yep. You want your kids to be your secondary benefit of your estate. But ex-wife has moved on. She either has a boyfriend, new husband, whatever, and you purposefully want to exclude the new boyfriend or the new husband. Is there a way to make the wife the number one beneficiary? And if she passes, it doesn't go to her husband or partner. It then goes directly to the children.
Yep, that's a good question. The answer is Anything other than a free and clear distribution to somebody involves some form of the trust, right? If I give you a dollar bill and there's no strings attached, that's your money. There's no trust there. Anything other than that is some function or some version of a trust, right? So if I die and an asset goes to an ex-spouse or whoever, and there's no trust involved, that's a free and clear distribution. It's their property. That will almost never make it to anybody other than them. So in that specific circumstance, what you would do is in your living trust, put your assets into it, and then say, when I die, person, ABC has the lifetime right to live in the house, rent free, maybe, whatever it looks like, or the whole property is theirs until they die. And then when they die, then it goes back to other people, your kids or whoever the remainder beneficiaries are. And the only way that ever works is if it involves some form of trust, because a trust is how you retain control after you die. If you have no trust, you control nothing after you've died. And so in that circumstance, if you give it to them free and clear via deed or anything else, it's their property and it becomes part of their estate through their own breakups or bankruptcies or divorce or anything else. It would be a miracle if that property ever went to anybody other than the person you left it to, right? The person you leave it to, if you don't leave it in trust, they can turn around and do their own estate plan tomorrow that says, I give everything I own to these people, and their estate plan governs their property. If you don't leave it to them in trust, it's their property. So under that circumstance, the only way you could ever accomplish that, put your assets into a trust, specify the terms of who gets what, when, and under what terms. And that's the overall benefit of a trust later on. Only a trust can do that. No other real vehicle would cover that circumstance. It would basically just be their property. They could do with it as they see fit.
Okay. And these are more kind of specific to being able to work directly with you, John.
Yep.
So let's say, for example, me and my spouse both want to come to you to get a will done, and we want to do a living trust and everything else. My question would be, if my spouse does not speak English, maybe they speak Spanish or Mandarin or something like that, do you have an interpreter that could help with any of that, just so that way they understand fully what they're getting themselves into as we do the will together?
Yeah, I mean, we can arrange that. The chief obstacle that we kind of have to address is if the documents themselves can't be read or understood by the person that creates them, the person signing it, the spouse. That it's going to be really hard to enforce that later on. If a judge looked at that and said, the person who created this trust speaks only Spanish, this trust is written 100% in English, and then the attorney's like, well, I had a translator and all that, it's a real dicey situation, because somebody contesting that document could say she had no understand. She wasn't even able to review the documents after the fact. So, we can arrange for interpreters, but probably better to, it depends on their fluency in English or any other language. If all they understand is the other language and nothing in English, the actual documents themselves should be prepared in the language that they understand. Because again, estate planning is their wishes and their intentions. And if they have no ability to read their own documents, not like everybody reads every page of their trust, but if they can't pick up their trust at any time and figure out what's there, it should be in their language. And that's a big deal. Obviously, we're in California, the Pacific Rim, it comes up all the time. So, I'm happy, a spouse can translate part of it, at least the discussions. But if one of the spouses creating the estate plan has no ability to read their document, it should be written in the language in which they can understand. That's something that I mean, it's very important.
And so just to clarify that, let's say, just giving the example, me and my spouse, we want to do a will together. My spouse doesn't speak English. They only speak Spanish. Would the will be drafted in Spanish? And then when it gets filed with, the county or with the financial institution that I have my trust with, would it then need to be filed with two versions, Spanish and English, or how would that even work?
I don't know about like recording and filing and all that. For that family, I would absolutely recommend two sets of documents.
Okay.
for the, as the same thing, or work with an attorney who is bilingual and fluent in everything, but also has the ability, the software to draft documents in both languages. And if that's the case, then either spouse can read their document, say, yes, that's what I meant. If somebody
Okay.
challenges a trust or a will, and like the fundamental question number one is, did this person understand what they were signing? And if they can't read the document, then how could they understand? Like, they're trusting somebody else to explain it to them, a spouse or whatever. My gut level is that they should have their documents prepared in their language primarily. That's how it's done in court, in contract law, in a wide variety of fields. If they're going to be signing a legal document, they need to be able to read it and understand it for themselves, not through somebody else.
I think that's fair and very ethical for sure. And then the last question kind of came in that was about more Patelco. Do you need to pay anything to become a member? And the direct answer to that is no. I did see a couple of questions. How can I join? How can do I need to pay money right now? No, there's no cost to join Patelco. So if you do want to open your membership, that way you can either take advantage of some of the services and offers that we have, or also in combination, take advantage of the wonderful offer that John Eric Fraker has given. You can either stay on after the conclusion of this webinar, which will be within a couple of moments, or alternatively, you can join online, over the phone, at a local branch, or we have our virtual service hours coming up on Friday. You're welcome to join us then as well. I know and realize that most of you have been on the call with us now for roughly 2 hours, so I know that you probably have other things you need to get back to. And if there are no other questions, comments, or concerns, we'll go ahead and conclude the webinar now, and we'll go ahead and hang around in case you do want to have any kind of one-on-one conversation or side conversation. And we'll be here and available for you for at least the next hour, if not going further. And once again, I'll be sending out an email within the next couple of hours for the recording of this webinar, and also any other information that John Eric Fraker wants to make sure that you have in hand as well. And I see that there is another question. Does Patelco have mobile banking? Yes, absolutely. We do have a full capability. You can do your banking over the phone, on your mobile app, online, or through through a tablet. So if you do have any other questions and you wish to speak with us one-on-one, please definitely, you can send me a note in the chat, and I am more than happy to break off in a breakout meeting with you and speak with you privately one-on-one. And if you do wish to join, you're also welcome to stay, and we can break you out in a one-on-one meeting with Brenda. Thank you so much. I'm seeing lots of gratitude in the chat room. Thank you very, very much, everyone.
Thank you, Melinda, for hosting us.
Yeah, thank you, Melinda.
Oh, you're so welcome, Gina. Thank you so much. There's so much love in the chat room right now. Thank you. All right, and I'll go ahead and go on. Oh, go ahead, Gina. I'm sorry.
Well, I'm just want to say thank you, Caltrans employees, for participating, and thank you all. Thank you, John and Melinda. I'll talk to you later. Bye.
Okay, sounds good. Thanks, Gina. And I'll go ahead and hang on for just a couple more minutes in case anybody does want to meet with us one-on-one. All right. And if anybody has any questions about membership, or if they just kind of want to talk one-on-one with John, you can definitely ping me, send me a private message in the chat, or you're welcome to take yourself off mute and I can pop into a breakout room with you.